everyone. Hope everyone's doing well. My name is Lorena Guzman Diaz. I'm an entertainment and arts lawyer at Weissman Law, and it's my pleasure to kick off the first event in a series of multiple online panels and seminars for creators and artists that we're going to be putting together over the next year. These sessions are going to be covering a wide range of essential legal and business topics that are useful for anyone working in the creative industries, such as all of you, hopefully. So if you're interested in attending future sessions, you like the one today, be sure to quick plug, follow Weissman Law and sign up for a newsletter for more info. So today in our inaugural session, we're going to focus on navigating contracts and payment issues when dealing with both brands and agencies. We have a fantastic lineup of speakers. Adam Weissman, the founder of Weissman Law in New York City, my boss, who I work with, Tahir Basheer, who's a partner at Sheridans in London, and then Aleksandra Hilvert, who's the founder of Vault Legal and a senior litigator at Johnson & Johnson in LA. Each of them brings, wealth of experience and is going to provide all of you with critical insights on crafting contracts to ensure that your rights are protected and to secure your payments when working with any type of industry players. After the discussion, which will be divided into kind of 3 different topics, and each panelist will address the different issues, we'll open the floor for a 20-minute Q&A session, so you'll have the chance to ask your questions and engage with our speakers directly. So before we get started, I do need to disclaim that the info presented in this presentation is for informational purposes only. It should not be considered legal advice. We're lawyers, so we have to cover our bases. So please consult with a qualified legal professional on any guidance for any specific legal matter you may have. So now, without further ado, I'm going to hand over the virtual stage to Adam, who's going to introduce himself and the other panelists, and he's going to kick off today's discussion. Adam, please, the floor is yours.
Thanks so much, Lorena, and welcome everybody. I see off the bat we've got a really nice mix of professionals, some lawyers, accountants that I'm familiar with that I haven't met, as well as people in the creator space, some artists that I know I work with, and probably work with some of the other lawyers on this call too. Now, the purpose of today's talk, and really a series of panels that we're going to be putting together over the next year, is to make some of these legal and business concepts a little more digestible for the folks out there. I will say that today's 1 hour that we're spending together is not meant to be a substitute for legal advice or for 3 years in law school and decades of experience, but it is meant to give you some tools for your toolkit, things that you should have in the back of your mind if you as a creator are dealing with brands or other types of clients. Just to give you a little bit of background on myself, I am the founder of Weissman Law, which is a New York-based arts and entertainment transactional practice founded in 2017. We deal with a wide range of clients in the creator space, photography, film, commercial production, things that have to deal with copyright, trademark, branding issues, and a whole slew of other things in the art and entertainment world. Before I go into the topics that we're going to cover today, I am very pleased to introduce 2 colleagues that are going to be joining us and giving their insights as well. First, I will turn this to Tahir to speak a little bit about himself.
Thank you, Adam. Nice to meet you all. I guess I'm the UK equivalent of Adam, if I can give myself that flattery. So I'm a partner at a London entertainment and technology law firm called Sheridans. I've been in the industry for probably 20 odd years now, and have spanned all sorts of content creation across entertainment, from music to digital to live entertainment, through to audio visual. I guess the concept of content creators now includes digital content creators who I work with a lot, and even they are becoming production houses. So the legal issues are becoming, a bit more complex and a bit more thorough. I would say that the business of content creation has become a bit more professional over the years, and yeah, so this is where we come in. I'll hand over to Alex.
Right. Thank you. Thanks to Tahir, and thanks Adam for organizing all this. It's an exciting to be part of this. So thank you. My name is Aleksandra Hilvert. I am, throw in another time zone. I'm in LA, so we've got basically the world map covered. I'm in Beverly Hills. I'm an entertainment lawyer. I litigate primarily, and I do a little bit of transactional, but I usually save it for the guys who really know it. I started entertainment litigation about 15 years ago, and I primarily work in copyright infringement, trademark infringement, soft IP matters, intellectual property. And I also do a lot of defamation cases, breach of contract, distribution agreements, things of that nature. When the contract is breached, that's when I kind of step in. I'm hired to sue. I sue in federal court and state court. And I also, a couple years ago, started my own little side hustle, side practice called Vault Legal. And what I do with Vault Legal is I started realizing over the years that people don't like to pay their bills. People, companies, individuals don't often timely pay. And it really leaves individuals and businesses in a state of, frustration because they completed their end of the bargain. So they, it's frustrating when you don't get paid. Everybody wants to get paid. You do a job, you want to get paid. So I started Vault Legal to help people and businesses who are not paid timely to recover on a contingency only. Meaning I'm not like a typical lawyer with Vault Legal. I just get paid when I close the account. Meaning there's no upfront retainer. And it's been great. I represent a lot of individuals in the space, content creators, a PR firm, small businesses that cater to the entertainment industry, but also businesses outside of that, and help with their accounts receivable to help them, make sure the lights can stay on. So that's kind of a little bit of my background and what led me to kind of this panel today to help hopefully give some insight as to what can be done so you don't have to hire me.
Having Alex put together a firm structure like that is so helpful because I think for most of us on this call, when we're talking about payment issues with creators, we're not talking about multi-million-dollar cases where we know there's going to be pretty decent recovery on the other end. We're talking about smaller amounts that traditionally might be a little bit tough to recover, particularly with the help of a lawyer. So understanding on the outset what you should be doing to protect yourself and then knowing what your options are when things do go wrong are crucial to long-term success. So with that in mind, I'm just going to give you a really brief overview of the things we're going to cover today. We're going to be going over 3 overarching topics. The first one is looking at contracts, the types of things you should be considering for your own protection and for certainty before you start a job. The second, we'll be dealing with brand payment issues, specifically what happens if and when it seems like you might not be getting paid or might not be getting paid on the terms you agreed to. And finally, the last one, a little bit out of left field or a little bit unrelated to the top 2, but just as important, if not more important, is how to deal with payment issues and other similar issues if you are represented by an agent or manager. I will say that I believe all 3 of us have acted both on behalf of talent and on behalf of brands, managers, and agents. So we're coming at this from the perspective of having seen it all. With that being said, if there's something we don't cover, we are going to save the last 20 minutes or so to an open Q&A. So please save your questions till the end. That's usually the most exciting part. Write them down, let us know, and then hopefully we'll have time for everybody. By the way, if we don't have time to address your question, I will put it out there that myself and I'm going to volunteer my 2 co-panelists are available to chat later on. We'll make sure that our contact information is up there before we end this thing. But with that in mind, I'm going to get us into the first topic, which is talking about things that you need to include in your contracts when you're dealing with brands and other types of clients to ensure that you get paid, to ensure that there's certainty. And I think the big takeaway that you're going to get from this initial part of the presentation is if something's not in writing on a piece of paper, you cannot assume that it's agreed upon. And really the big thing about contracts in general is not, oh, this is necessarily the thing that we're going to have to use if we have to sue somebody. That's obviously the worst case scenario. But the thing that you should be thinking when you are working on a contract from the outset is what is the other side's expectations? And how do we make sure that we're on the same page as them? And the more detailed we can get in a contract, the less issues there are going to be when we start talking about those things. So I'm going to go into 5 or 6 different topics that I like to consider when working on contracts. Then I'm going to hand it over to Tahir to talk about some things from his perspective. And finally, on this topic, Alex will take the end. So let's just chat about a bunch of general things you need to think about. Clear payment terms. You know, obviously the first thing you're thinking about when you're talking to a brand or another client is how much are they going to pay me for the work that I'm doing? But just getting that number of how much you're going to get paid is not sufficient to know how you're going to get paid. Don't assume that because you're working with a big multinational brand that they have a very specific way of paying you that you just have to adhere to, or more importantly, that they might just dictate to you. Make sure that it's in the contract. You need to talk about things like deadlines, amounts, most importantly, conditions for when payment is going to be made. Is it going to be net 30 from signing the contract? Is it going to be net 30 from handing over your last deliverable? Or is it going to be net 30 from handing over your social metrics if you're a content creator who's working on a campaign with them? All of these things should be stated somewhere. And if they aren't stated, I can tell you from experience, they're going to fall in favor of the brand, the person who's paying you. So keep in mind, if you have this conversation up front, get those things out of the way. They won't be questions later on, and you won't have to sort of fall at the mercy of the brand who just gets to dictate payment terms unilaterally. On that note, especially if the payment terms are conditional, things you need to do are define deliverables. Talk about scope, talk about deadlines, talk about revisions, particularly if you're a content creator. We know in this day and age, brands will have a stranglehold on the stuff that you put out there. They're always going to want approval rights over your content before it gets published. That's normal. But the thing that you need to discuss is, okay, how does that actually play out? If you leave it open-ended and a brand has just unilateral approval rights without any defined schedule, chances are they're going to be able to ask you to do an unlimited amount of revisions because, again, they're holding the money, they get to dictate terms. What you should be doing upfront is talking about, okay, we are happy to give you approval rights, but we want to limit it, to example, for maybe 1 round of revisions or 2 rounds of revisions. Different brands are going to have different criteria and they're going to have different requirements. But again, it's just one of those things you need to talk about and you need to have a conversation about before you get started. Otherwise, that amount of money that you agreed to could be far less valuable than you thought it was. If you were end up spending 3 months on revisions for something that you thought should have taken a week, you're going to feel like that 10K or 20K fee that you're getting paid by the brand isn't worth as much as what it was when you initially started that conversation. Kind of piggybacking off of that as well, you're defining the scope, you're defining the deadlines. The other thing that goes directly to payment and goes directly to what you should be asking for are intellectual property rights. These are broad things that I will tell you 10 years ago when I started looking at content creator agreements weren't really well defined. In fact, 10 years ago when I started looking at content creator agreements, we barely had any contracts. It was a lot of just handshakes and text messages and money being sent through PayPal back and forth. But today, the intellectual property section is, if you're dealing with a sophisticated brand or agency, one of the largest sections in the contract you're going to see. And there are reasons for that. You need to explain who's going to own the content. You need to explain what type of license you're granting. We understand now in the industry, generally speaking, and I know Tahir can probably comment on this if I'm overstepping, but generally speaking, content creators get to maintain ownership of their content, and the brands are given a very specific license. That matches in a lot of other industries. Photographers generally get to keep ownership over the photographs they're creating, and there are some very specific circumstances where a brand might actually buy that out. The same thing goes in the influencer space. But you need to understand on top of that, how the brand is going to be licensing their content, or rather how you're licensing the content to the brand, what they can do with it. Simply saying that they can use it is not going to be sufficient. Can they post it on their Instagram? Can they take it from their Instagram and then boost it? Can they make dark posts on it? There are all these different things behind it that actually need to be addressed because usage goes to the value of what you're getting paid. So we have all of these, what I'll call deal terms that are incredibly important. You need to think about, you ideally have to discuss, and then we get into slightly more technical pieces. You want to talk about jurisdiction, talk about if something does go wrong, where are we going to court to deal with this thing? And this is going to become particularly important when Tahir takes over in a few minutes. Because as you know, this day and age, you might be based in one state, dealing with a brand based in another state or in an entirely different country. How are you going to recover money? is a huge piece of the picture that you need to figure out before getting started. I will say though, very rarely are you able to change jurisdiction in your favor if a brand wants something else, because there is sort of a unsaid rule that the person that's paying gets to choose jurisdiction. Sometimes there are exceptions to that. Think about it. Is there a live element to what you're doing? Are you required to go to a store or shoot on site somewhere? If you are, maybe it makes sense to keep jurisdiction there. If you're shooting everything on your own, though, and the brand's based somewhere else, that's going to be a large conversation. Going into more technical pieces again, looking at things like termination clauses. Does the brand have the unilateral ability to terminate without reason? Can they just cancel a campaign halfway through? If they are able to do that, you want to talk about things like kill fees. Do you get paid if they terminate early? Do you get paid if they terminate early because it's your fault? Think about these things. If you have a campaign that lasts 6 months and you're doing something once every 6 months, once every month, each month during that 6 month period, would it be reasonable to not get paid at all if something goes wrong in the last month and they have to cancel? Probably not. So you want to talk about those situations and how to deal with those things. And finally, think about things like late payment penalties. And this is going to be what I'll call next level contract pieces that you're probably not going to be able to get with many brands. But going into the notion of payment being so important, think about if you're dealing with a brand you've dealt with before that you know has paid you late, can you incorporate interest on late payment into that contract so you have a little more teeth if and when you need to go after them? And with that being said, I just kind of went ad nauseum for the last 10 minutes. I'm going to hand this over to Tahir, who's going to give some more points from his perspective.
Thank you, Adam. That was very interesting. I guess I'll probably look at it from maybe a bit more of an international perspective. Um, in this digital world, ultimately campaigns are global. So we often get involved in those global campaigns, either for the brand or for the people that are delivering the deliverables. And there's quite a few things to think about if you've got a global or cross-jurisdictional campaign, because there are international differences between laws in different countries. And so that's when Adam talked about earlier on, this choice of law clause comes in. And that's quite heavily negotiated. You have the ability, I mean, as Adam pointed out, typically the party that's paying is trying to dictate the term jurisdiction, what law we're applying, and secondly, which territory that law will be decided in, because you can have split laws and jurisdictions, and maybe Alex might talk about that a bit later on as well. Thinking about other types of approaches before actually getting to the legal jurisdiction point. Talk about other types of dispute resolution, mediation, arbitration is another way of doing it, because ultimately what we're trying to do is get to a resolution, and sometimes having a mechanism which allows you to get to that resolution is the important point, as opposed to having to be in an actual court dispute. There are some advantages and disadvantages of arbitration versus mediation. I mean, first of all, an arbitration process can be confidential, as opposed to being in a court setting, which can become public. It's meant to be quicker and more efficient and more costly, debatable in some circumstances, but that's what it's meant to do. And sometimes you're more able to have a neutral territory for arbitration. If there's disputes in I don't know, in Asia, then obviously often Singapore is looked at. Disputes in Europe, you might look at Switzerland. Disputes in the States, I guess, GEMS arbitration is something that's commonly comes up in contracts. So that's worth kind of considering. Other things to think about with respect to international type of deals is sometimes the legal clauses might have different impacts in different territories. So some clauses aren't actually enforceable in some territories. Quite commonly, the penalty clauses if you default. And in some territories like the UK, for example, you can't just slap on $1 million if you don't deliver this. It's got to be something that's reasonable to put the um, non-defaulting party in a position as though the contract had been adhered to, as opposed to a penalty clause. Similarly, things like non-compete clauses can vary in different territories, particularly in things like employment contexts. Um, you know, famously, California versus the UK has very, very different approaches when it comes to non-compete provisions. And often that's a reflection of the kind of cultural norm in that territory as well. Also things like, certainly in the digital content space, regulation, terms and conditions around competitions vary drastically in different territories, even in different states in the US. Advertising laws in some territories like the UK and the US, they're relatively similar. So the Advertising Standards Authority in the UK is quite similar to the FTC in the States. But then obviously, if you look at advertising regulations in places like the Middle East versus China, they can be very, very different. So this is why, having legal colleagues in different territories and being able to work with them works quite well. So often when we work on a global campaign, we might reach out to the likes of Adam and Alex on certain provisions to make sure that for that territory it fits well. And then I guess things like currency, let's take the US and the UK, which currency are we applying in a particular situation? Um, uh, Not only which currency, so being clear on that, but also being clear on what happens if there's currency fluctuations. Because obviously if you have currency fluctuations, then one party is winning and one party is losing. So often you'll put in provisions which fix the currency either to a specific rate or will be tagged to a base rate of a particular country or a particular bank, or there'll be a mechanism which says that if the currency at the date of signing fluctuates by more than X%, then there's a readjustment on the currency, or at least a conversation about how that works. So that's another consideration with international deals. I guess tax is quite a big one, and we've got some accountants here on this call, which is useful. But cross-jurisdictionally, I mean, I actually had it today as a good example where we were working on a production and we had a talent that was working on the production. The talent got paid. The talent lived in Dubai. The production was in the UK. There was a withholding issue. And the talent complained because they were saying, well, actually, I thought I was getting paid X, but you've just withheld Y from that. And the contract was very clear that ultimately the talent is responsible for their own taxes. And what transpired was typically, if that talent was in the US, it wouldn't be such an issue because you'd have double tax treaties between the two countries. And so it's really filling out a few forms, and then you essentially become, you get your tax back in your local territory, or you can offset it. But in this instance, because the talent was in Dubai, they're not paying tax, so they can't offset that tax that had been withheld in the UK. But it was good that we had very, very clear terms in the contract which set that out and set out the responsibilities around that. So that's an important thing. And then I guess issues around force majeure provisions, which essentially talk about what happens if there's a disaster that happens, which then frustrates the contract. And a perfect example of that, perfect's not the right word, but a very where this clause came out really, and everyone was looking at their contracts, was obviously when COVID hit, because at that point people couldn't deliver, but there were payments that had been made, there were insurance policies that backed certain contracts, and so the specific language of the force majeure clause was very, very closely looked at. We had one particular case where the force majeure clause actually referenced flu-like symptoms and pandemics, and the insurers were hesitant to pay. It was a tour, an international tour, and the insurers were very hesitant to pay out in that circumstance. But I would say probably more by luck than design, the way we drafted the clause actually fitted in specifically to the definition of a pandemic and COVID that the World Health Organization had put down. So it couldn't be said, so we referenced them, and it couldn't be said that the insurers should avoid paying. And that was, in the millions. That, it was the different 3 words were the difference between not paying out and paying out. So that's a good example of having a look at those and seeing what happens there. And often with force majeure scenarios, it's, can we delay this scenario as opposed to the contract immediately terminating? What are the mechanisms that are reasonable in this situation for both parties?
And I think when you're dealing with force majeure, going back to the pandemic, because this was something that I had dozens of cases at the time, or files at the time dealing with it, was if you are on the talent side, if you're a creator, make sure that the force majeure doesn't simply give the brand a means to not pay you because of the mere existence of a pandemic. And it really goes to what Tahir is saying about the language being so crucial, where we had quite literally a few dozen situations where brands went to us and said, "Hey, it's a pandemic. We don't have to pay you." And we were able to go, "Well, no, it is a pandemic, but there's nothing that is causing the pandemic. Sorry, that is not enabling you to pay us because of the pandemic." So it's those two pieces of, is there the existence of something outside of our control, and how does that actually affect you? And you need to consider both of those things in force majeures, because I've certainly seen provisions tossed in where the mere existence of an outside force would somehow just absolve a party of its responsibilities, and that would be a poorly drafted paragraph. But with that in mind, talking about problems, let's turn to Alex to round off this final topic, or this topic.
Great. Thanks. Just real quick, I had a couple more points I wanted to make. One is the importance of due diligence on a company that you're going to be working with. If you sign up to be a brand ambassador or do some content for a brand, you are essentially an independent contractor. You are essentially an extension of that brand. So it's up to you. It's contingent upon you to make sure you've done your homework, you've done your research. Where's the brand domiciled? Are they established? I see so often these brands pop up on Instagram overnight, and we all know that you can have, 1 million followers, you can buy followers. So if the brand, even if they look legitimate online on social media, that's not enough. That's just the tip of the iceberg. You need to look up their website presence, their online presence. Do they have corporate formation documents in the state where they're domiciled or the country where they're domiciled? You've got to really peel back those layers, because if you don't, you're just setting yourself up for a situation where the brand's up and they've got millions of followers, and you do a deal and you're excited about the deal and you put in the time, you put in the energy, the campaign goes viral, and all of a sudden the company's gone and they've, taken all the money and the sales, etc. The other thing is having multiple points of contact with your brand, whether it's large or small. I mean, especially in the larger brands, you're gonna want to have contact information for not only the salesperson or the brand marketing person you're working with, but also accounts receivable, who owns the brand. All of this goes into your due diligence. And I will tell you that if you have all that teed up and buttoned up, and they feel that energy, they feel like, oh, wow, this person's really knows about us and has done their homework, they're more likely to pay you when that payment term comes due, because there's something psychological about, the way that you carry yourself and the information that you provide and how you speak. If you have all of these things lined up and you know what kill fees are, and you know that, force majeure, well, I got to be careful on that. It's something that shifts in this brand's mind. They think, okay, this isn't just somebody who's online trying to create some content and make a video and get a little bit of money. So you are more likely to be paid if you have all those things lined up, all your T's dotted. And one thing that I believe Adam briefly mentioned that I just want to touch on, speaking of the psychological thing that happens with brands and a way to make sure you do get paid, is getting as much as you can up front. Because what I've seen happen, usually you can negotiate at least half up front. If a brand is not willing to give you anything up front, that's a red flag. That to me is, well, why? You want me to do the work, but you're not willing to pay me at least 50% or, 30%, what have you, and kind of space those payments out. Because if the brand does pay you half, they are more than likely going to pay you the other half. And here's why. Because now they've got your payment information, you're in their system, right? I mean, that's a whole nother topic about making sure they have your W-9 and they've got your Zelle information or Venmo or whatever it is, your ACH for wires. If they have all that and you're already teed up in their vendor database, it's easier, it's way easier for them to pay you the other half. And psychologically, they've already paid you half. So they might as well pay you the other half when the campaign closes or you wrap up your end of the bargain. But getting as much as you can up front is huge. I've also seen situations recently where even if you get half up front, the brand will try to negotiate you down from the balance that's due by saying, oh, we've run into budgetary issues, or gosh, that campaign didn't do as well as we had hoped, or we're really strapped right now, but we can pay you half of what you're owed on the other half, right? And so now they're using your contractual payment term as the ceiling for negotiating. And that's not fair. So again, going back to getting as much as you can up front. And then when they do come back and say, we can only pay you half of what you're owed, say, no, I'm entitled to the entire amount. Pay me, half of that, 25%, another 25% in a month. But there's just no room for it. These brands have budgets. They knew going into negotiations with you how much they had in their budget. So it's not going to fly.
It's what to do when there are payment issues with the brand. And I will say, I do think the advice or the suggestion to try to get payment up front is a good one. If you're dealing with a larger established brand, though, I can tell you they're going to say no 99% of the time. And that's okay. I think to Alex's point, though, there's never a harm in asking, and that's really, if you're going to have another takeaway from today, it's if you want something, ask for it. And the worst response you can get is no. It's going to be pretty unlikely that a brand, gives you the cold shoulder and decides to cancel a campaign before you sign a contract simply because you asked the question. Know when to stop asking questions, but certainly know when to ask. But I would say in the context of newer brands or international brands, when that payment is going to be twice as hard to collect on if something goes wrong, asking for payment up front is an amazing idea. Something I do very often when it's a brand or an agency that we've never really heard of before. But just know that I think contrasting that with established brands who have accounting teams of hundreds of people, it's going to be tough to get payment up front. That being said, great idea to ask if and when appropriate. Kind of taking a step back, talking about Alex's great example of what happens if you get paid up front and then a brand turns around and on the latter half of payment goes, oh, sorry, budget's changed, et cetera, et cetera. If you've done the legwork and you have that contract in place and you have all the details we were talking about, however this is going to play out, it's going to be easier than the alternative of you not having a very clear contract with very clear payment terms. To Alex's point, though, when this happens, you need to open up a dialogue. You need to start talking to the brand and understanding what's going on. Simply putting your foot down and saying, no, this is my contract will work sometimes, depending on who you're dealing with. But keep in mind, just like Alex was saying, you are a business. If you're a content creator, you are running a business. And part of running a successful business is learning how to talk the talk and learning how to deal with the salesperson or creative team or manager or whatever your main point of contact is at that brand or at that agency, and understand that they have different priorities than you. And yes, maybe sometimes that priority might be not paying you, but more often than not, it's something internal is happening that you need to figure out. So opening up that dialogue and understanding how to open the conversation in a friendly, not necessarily confrontational, but still assertive way is an art and a skill. And it's something that us as lawyers we work on our entire careers. They don't teach you that in law school, but the second you're thrown into a situation with a lawyer on the other side of a deal or the owner of a company, your wheels start turning and you start developing your own rapport and your own way of talking. And that's something that you as a content creator needs to figure out too. While you're doing that, while you're playing Mr. or Mrs. Nice Guy on the side, other thing you should be doing if a brand has come back to you and says, oh, there's a problem, we can't pay you now, or payment's going to be late, is start documenting everything. And this is key. You might be having a productive conversation with somebody over the phone, but if things go south, you won't be able to turn back to that conversation unless it's been recorded or you've taken contemporaneous notes or you've sent an email summarizing it. You need to do something to make sure that there's a record of everything that's happening. So if things do escalate, if you do decide you need to go the formal legal route, you need to bring in Alex, you need to go to small claims court, you need to send an angry letter, something like that. You have all of that lead up beforehand. I will make one caveat. If you are recording somebody, make sure you're familiar with your jurisdiction's laws on consent for recording with that. Sorry, on laws on recording without consent from the other side. And it's going to be different depending on where you live. So I'm not even going to go into detail about that, but I do have to make that caveat. But the bottom line is you have two tracks going. You have this open dialogue where you are trying to see what you can get. And I would say don't offer anything up front. If they want to just reduce your payment for no good reason, you shouldn't be accepting that, but you should be listening. But at the same time, start setting yourself up, imagining, okay, what happens if this conversation doesn't go well? How do I get all my ducks in a row? How do I make sure that everything that's happening is recorded? So if we do need to take this thing to court, or I do need to bring in a lawyer, the judge or my lawyer or whoever is helping me is able to look at the entire situation and understand it clearly without having to just go back to your memory. With that in mind, I'm going to turn to Tahir for some of his strategies.
I mean, I agree. It is an art to get paid. I mean, part of it is carrot, part of it is stick, part of it is annoyance. I mean, I firmly believe in persistence power as a good example, which is, not just chasing once, but chasing regularly. But there are different ways of being persuasive, and some of them are well, being very clear about what the communication has been, turning to specific agreements that you've got, your contracts, etc. Also the timing of, deliverables versus payment, holding back on stuff sometimes is important because it's an exchange. If I'm not going to get paid, then you're not going to get this deliverable. Or if you'd originally in your contract, when Adam talked about IP, if the IP usage is contingent on payment, then you've immediately got the ability to say, well, you can't use the IP, even if it's out there, you need to pull everything down until I've been paid because the license is now terminated. So aspects like that are important. Sometimes having different voices as well. I mean, the lawyers are in one place, but if you've got account managers, on both sides of the table, it's worth them talking to each other. Maybe a good cop, bad cop scenario. There's lots of different ways of trying to get get payment, and the hard skill is the legal part. But as Alex pointed out earlier, there is a psychological bit. Maybe I'll hand over to Alex to see what she has to say on that point.
Great, thank you. Absolutely. I mean, I think what we're trying to emphasize here is that you win or lose your case before you even walk up to the courthouse because of the evidence you have or don't have. So if you have a great record, then you are more likely to be that squeaky wheel to get paid. But if you, for example, don't follow up, if you send an invoice, you need to calendar that invoice deadline. We're all very busy. We all have a lot going on personally, professionally, but sending out an invoice is just one piece of the puzzle. You're going to have to then have that date on the ready, and maybe 3 days before, hey, it's me, I'm following up, invoice is due in 3 days. Day before, hey, here's my Zelle information again, making sure we're all set for the payment. And then when that doesn't come due, you've got a couple of communications in writing, and you've got, now it's due. Now it's like, hey, I really didn't want this to come to this, but I really need to get paid, blah, blah, blah. The other thing to think about is that did you do everything you were contractually obligated to do? I've seen situations where brands will ignore payment requests and leave the creator in a situation where they're like, well, what happened? I'm not getting paid. I need to lawyer up, da da da. Well, it turned out they hadn't turned in their metrics after the campaign. But the brand isn't going to hold your hand and make sure you do all that. The brand's just going to be like, great, we just saved $20,000 because so-and-so didn't read their contract and didn't do all of the terms that they were negotiated to comply with. So if you go through the contract, you've got everything buttoned up, you know you did your end of the bargain, and you're reaching out to them, having that kind of, multiple points of contact again is great. CCing individuals that are part of your team. And I just saw, who was it? Some actor had like a fake agent, and when they were starting, it was like Hugh Jackman or something. I don't know. It was somebody that like would be like, "Oh, I'm copying my agent," and it would just be them at a different email. So, as corny as that sounds, if you're really just like starting out and you don't have agent representation, you can have a, sam@blank.com and just be like, you can take that on and make yourself seem like you've got like a powerhouse behind you. I'm not saying, have like an identity crisis or start coming up with fake personalities, but there are ways to make your team or your entourage or, seem like it's bigger than it actually is before you get formal representation. The other thing to consider is if you get to the point where you've tried everything, you've tried, you've messaged, you've reached out, you've hit your wall. The one thing I will say that's really important before you hire a lawyer is to make sure you never disparage the brand or defame them in any way. Make sure that your language is always very professional, because that can really come back to haunt you. And I've seen situations where potential clients, because I had to say I cannot represent you in this matter, would just go on blast in this whole, disparaging campaign about certain individuals and companies. And that's just a really poor look. It's not in good taste. And it's also going to make other brands reconsider working with you if that's kind of your end game, or that's kind of your default when a payment is late or a payment doesn't come through. So just always remember, just lead with kindness, be professional. Maybe there was really a payment snafu, or maybe, somebody got fired who was in that department. I mean, things do happen, but you just want to make sure that you're constantly, emulating the type of professionalism that you would want someone to return to you. So now let's say you've done all that, you've been professional, enough is enough, you need to get a lawyer. So where do you turn? There are lawyers that, on the transactional side could help out, like Adam and Tahir, to maybe send a more formal demand letter, something, that has civil code references and talks about interest provisions and attorney's fees, et cetera. You could do that. But typically hiring a litigator is probably going to get you a little, get you to the end result faster, because a litigator is somebody that does typically go to court and is familiar with courthouse rules and procedures. It's very nuanced depending on what state you're in. And so if you have a litigator that sends a demand letter, well, now that brand is like, whoa, this could actually lead to a lawsuit. And there are a lot of considerations about going to that step, because one is the cost. You're either going to hire somebody on an hourly basis and pay their hourly rates to go after this brand, or on a contingency. So my firm does take these kinds of matters on a contingency, meaning I only get a fee if I'm able to recover. But I have a couple, tally things that need to be met before I can take that case on, which, it's a whole nother panel, but it's about also your time and how much you're willing to invest in this, because I will tell you that just hiring a lawyer does not mean that you are absolved of having to deal with this and the lawyer is going to run with it. The lawyer is going to look to you for, again, going back to the evidence, going back to communications, information, deliverables. And if you do sue to recover, that increases tenfold, because now there's discovery, which is, requests for production, and it's all very formal. It's a whole, again, and a whole nother panel we could do, but you are still going to be so tied to that process and that that case, that it is a consideration of how much time you want to put into this after you've already done the work and not gotten paid. And now you're going to be either paying out of pocket or on a contingency, but also still, you know, having to put in the time and do the work. So, and then, you know, I want to give it back to Adam, because there's these considerations with content creators that work with brands, but also what happens when you are represented by an agent or an agency, and all of a sudden your payments are coming in dribs and drabs. You know you got a big campaign payout, but gosh, they're really dragging their feet and giving you your cut, because now it's like a partnership you're in. So there's different considerations. So Adam, I'll let you talk about that.
Yeah, this last topic, because we're a little bit behind on schedule, and I do want to open the floor to questions in a few minutes. But essentially, if you are getting a manager or an agent in the space, and those are different things, although we won't go into the specifics of how they differ today. But if you are getting some sort of representation as a creator or any type of artist, there's a very good chance that as part of your representation agreement, they are going to be the entity collecting the funds from the brands that you work with on your behalf. And that means there's going to be a linchpin point between you and the brand that wouldn't otherwise exist. Why this is really important to think about before you sign your representation agreement is you need to ensure that if you are entering into a representation agreement, those terms on how payment works are very clear cut, because now you have that extra step to get paid. You are going to get paid slightly later than if it was brand directly to you. They are going to be taking their commission out of it. Are they going to be taking expenses out of it? I don't know. That needs to be said in the contract. Do you have full accounting rights? If something goes wrong, can you open up their books and take a look to actually decide if they are paying you late, or if the issue really is that they haven't been paid by the brand? These are all different things you need to think about upfront. And I will say that your management or your agency agreement is going to be usually far more long-reaching and more impactful than any single brand campaign you're on, because those people are going to be with you potentially for years. So getting that right from the outset is crucial. Now, before I turn this call to the audience to ask questions, I'm just going to let it to Tahir or Alex, if you have any final remarks you want to say and get in before we sort of start to wrap things up, please take the floor.
Yeah, I mean, I think one of the common threads of what we've talked about is simply whoever has the money has the power. So ultimately, if we talked earlier on about brands paying a chunk up front, that makes a difference, because now you've halved the power. We talk about in management scenarios, if managers are collecting income and there's a dispute between you, then there is an issue there. But obviously, there's two things with managers collecting income. One is who's chasing the debt from the brand, and what's the responsibility around that. And then secondly, once the money's come in, how quickly is it getting paid out? And then thirdly, I guess, is the talent not sitting in a position which is making them vulnerable because of the business vulnerability of the management company or the agency. So in that scenario, you always try and say that there should be a separate account, client account, trust account, where the money's sitting, so that if the management business goes bust, then that money doesn't go with it. But ultimately, there's a payoff. If the managers are collecting the money, then they're dealing with the admin of that. You're not dealing with the admin of that. You're getting paid a sum of money. If you're getting the money, then you're dealing with the admin of that, but you have the security of that. Sometimes there's a third party that collects the money. Sometimes it's the business manager, for example. So there are other ways of dealing with that.
I'll just add one more quick note before we open up to questions and answer. And that is that nobody wants to be in this situation where they're owed money. And I personally have been in this situation. I think we all have at some point. And it's what we're trying to do here today is just give everybody some notes, some thoughts as to how to protect themselves. I think there's been a lot of overarching themes. My biggest takeaway, if you could take away one thing, is just to be very, very diligent and very organized in your contracts and your note taking and your record keeping and following up, because that's the difference between somebody who's going to be a squeaky wheel and get through because wow, they've got it figured out, versus somebody who doesn't even follow up for payment, and you're going to be the last one on their totem pole, right? you're down here when so-and-so who's emailing every other day and, found their CEO on LinkedIn and is really squeaky wheel over here is going to get, that payment much, much faster. So hopefully we've been able to give you some insights and to protect you and your own emerging brand. So thank you.
Amazing. That 10 minutes or so, maybe 15 minutes. If anyone has any questions, please type them into the side and we'll address them on the fly.
I mean, Adam, there's one comment that was made earlier on by Evelyn, which talked about smaller brands having an individual owner serve as guarantor for payment. I mean, it's quite difficult getting individuals as guarantors on a brand deal, but often you might say that you've got either a parent company or I mean, sometimes the directors, but obviously, if you can have a guarantor, that helps. Or even if the money can be put aside into some sort of escrow account. Who's the escrow account holder is the difficulty. There are professional escrow account holders, but there's a cost to that as well.
Yeah, I think if you're doing like a year-long plus ambassador program or maybe a product licensing collaboration, you could certainly get creative in those respects and start making solutions like that. But if it's a 1 month campaign, for example, I doubt that conversation will even be had. Well, it looks like no one has any questions. I guess we've been
I
wildly
have some
comprehensive.
questions that I think
Yes,
could be
please,
helpful
Lorna.
for our audience. So how do you guys recommend that, kind of creators balance the need for clear payment terms with the flexibility that is required for creative projects? Like, how do they not come off super intense or like, push people away with that?
I can kind of start off. So I think it shows just a level of professionalism that you've been here before. You kind of know, this dance. You know how these things work, and so if anything, in my mind, it comes off as you have the experience and the professional wherewithal to know what you're entitled to. And if it seems like that brand is just not giving you any leeway, then maybe you don't want to be working with them because that's another red flag. That could be the second red flag if you're not seeing much of an online presence and then they're saying no, we have to pay you the whole amount 6 months after the campaign ends. Well, gosh, do you want to be putting your energy into that, or do you want to wait for the next one?
Yeah, I think coming at this as a creator first or artist first, there's a lot of internal struggle that you might have about being too business minded. But I think that truly you need to accept that as an internal piece and not something that brands that you're dealing with are even going to care about. And I agree to Alex's point. If you're coming at something with a professional approach, all buttoned up, knowing that you did your homework beforehand, you're going to get more out of them. So getting over that initial discomfort of speaking in that manner or doing the homework is going to pay off in the long term. And it eventually should be something that just becomes second nature. And yeah, to Alex's point, if you get a poor reception when you do speak like that to a brand, chances are the campaign's not going to go well. If things start off on a bad foot because you're just being professional, you know that when you hand your draft content over or when you go to get paid at the end of it, there's going to be some sort of a problem.
I mean,
I have one more question. This one's for Tahir specifically. So, are you able to discuss kind of like the importance of cultural and communication considerations or things to keep in mind when entering into a contract with international brands? Or if there's any tips you have for those matters?
Sure. So I once went into there was a big campaign which involved a Japanese brand, and there was a non-payment issue. And I once went into a meeting where I thought, it was going to be super productive and everybody was going to walk out hands, with hands having been shaken, principally because the Japanese brand said that they were going to send over 6 of their executives to the UK to have this discussion. So in my head, I thought, well, if they're going to that, you know, we're ill. Everything seemed great, and I basically got to the end. Okay, so what are you going to pay us? And they literally said, we're going to pay you nothing. And what I realized there, having spoken to a colleague of mine who's done a lot of business in Japan, was that the cultural approach that I took was absolutely not the right approach. So in Japan, there's a hierarchy system, there's a way of approaching stuff. So in some, extreme cases, I think having a bit of a cultural coach is important because it does actually make a difference. Secondly, I think sometimes things are lost in translation with territories where people don't talk the same language. And so sometimes we do have bilingual contracts where the contract has been specifically translated into the foreign language alongside the English language, just to be very, very, very clear as to what the terms are. And then thirdly, I think just knowing a little bit about the territory, things like, in some territories they have different holiday dates, being aware of that. We talked about force majeure in the Middle East, for example, in places like Saudi. If one member of the Saudi royal family passes away, that's 3 or 4 days of grieving in that country. So everything shuts down from a brand perspective. And if you think about how many people are in the Saudi royal family, that's quite a big event. So being aware of that in terms of how you put that in your contract. But certainly being aware of the cultural norms is important because certain territories have a very different way of doing business than others.
That's a great question. Really fascinating answer, and sounds like a terrifying story to be in the middle of. But with that, I think we will call this session to an end. I want to give thanks to Matthew Hoffman and the Trusted Advisors team for hosting this, and a very special thanks to Lorena for opening this up to us. And of course, an even bigger thanks to both Alex and Tahir for joining us today and providing any of their insight. As mentioned, if anyone has follow-up questions, wants to contact any of us, you can get our information from the posts that we've been making. Tahir over at Sheridans, Alex at Vault Legal, and myself at Weissman Law. Please follow all of us on Instagram, LinkedIn, TikTok, wherever you're active, because we will be doing more of these things in the future, and we'd love to have you join us again.